Dummy, dummy. Ah, omo.
Uncle, When is what? It's very fine.
Horrible things for money. I get up early every day.
Why is it that I need to change this FS? And how will I change it? If I edit it, I always edit it. It's not permanent.
Sometimes the appearance of person was intimidating.
What's your brother's second name? Oh, what did you do? What's his last name? But what's his first name? Second? No, that's his last name.
When I don't enter, so it's just for attendance because a lot of people just join just for attendance. Just attendance. But I have time to attend.
Why? Not be
All these guys.
boring. They can be very. Sometimes they don't make it relatable. Like how can you say? Now using the old example. It makes it so boring. Oh my god.
Hey, just that last.
No, Lou, mute.
That's just this. I think just as engineering guys, that's how we've been shaped and built, especially by our lecturer. So
Now, Lou, man, go to me.
Right?
You're going to end up with more degeneracy than
Obviously, I did finish, but I tried my best.
that's looking.
Hello, good evening, everybody. So you can talk now. Good evening, everybody. I want to be sure you all are there.
Good evening, Mark.
Okay, so thank God it's Friday. How has your classes been going? And I hope you've been doing your tests. I wish you all the best in all your tests and your forthcoming examination. Okay, so let's quickly go straight to why we are here. So today we are talking about privity of contracts. I just want to reiterate this. Okay, so we should all mute our devices at this point. You can mute your device, please. And please, I don't want us to strain ourselves like we did yesterday. I don't want to start writing names. I don't think that that should be. I don't think we should be doing that. Okay, so I'm trying to see if I can make somebody a pose. So those on YouTube, I hope you can hear me clearly. I'm not seeing anyone here, but then it's okay. And this class, you're supposed to be more than 500. We only have 114 students here.
Does she know?
Hi.
Yeah. They are not. Daniel, oh yeah, mute your.
So I think what I should have done was that when I was trying to, let me see this. Okay, so like we did yesterday, we are going to do a lot of charts, okay? So who can tell us on what privity of contract means? If you have heard of it anywhere, what does it mean? What does privity of contract mean?
Most times I did. You know, that time when meant to be talk, one plenty in my head. I know life for you. I just send you video of the one story who just walk now.
So I'm seeing there's nobody typing. So that means we don't have anyone present here. No, I said privity of contract. So let me just type it here. Privity of contracts. So Benjamin, that's good, but I think you just got this maybe from the internet because you are not telling me the real privity of contract. You are just trying to say something that some are next things. Okay, so Rachel said it simply means only those who sign the contract can be affected by it or can enforce it. All right, that is good. So I want to believe Google is at work and also AI is at work. Okay, so what privity of contract means is that, let's just say, for example, if A and B enters into a contract in which they both confer benefits or obligation on C, listen to me. A and B enters into a contract, but the beneficiary of that contract is C. Generally, under the law of contract, C cannot sue either A or B for the enforcement of that contract. That is what it means, privity of contract. I'll repeat myself again. Privity of contract means that, for instance, A and B enters into a contract, but then they made B. Who is Salim? Why are we seeing you in a vehicle? Are you in this class at all?
Steven, mute your mic.
Okay, so like I said, please, if you want them to mute their mouth, you don't need to speak up. You can always send a message to them or something. Okay? So you're also interfering. Thank you for helping me police them. But then you can do that by just sending a quiet message to them. So like I said, I'm giving you an instance of where that happens. And it happens where, for example, A and B enters into a contract, but then they made C the beneficiary of that contract. Under the law of contract, it means that C cannot then sue either of them to court saying, but you said I'm meant to benefit from this contract. Why are you not giving me the money? So let me give you an example. Under the law of contract, where let's assume your parent, they rented an apartment for you off campus. So the contract is between them and the landlord. What privity of contract is saying that if the landlord defaults in doing what is necessary in the house, you cannot sue the landlord. Or if your parents refuse to finish making the payments, you cannot sue your parents. That is what the privity of contract is saying. Do you think that's a good law or it's bad? Do you think it's okay to just that you cannot sue either of them? So Daniel says good, Ayobami says bad, and all of that. So normally it is seen as being good. It's a good law, right? But then, thank you, I'm saying I don't think it is good and all of that. I love this, your contributions. But what we are saying here is that it's a good law. It's a good concept. But then there are some times that things may not go in that way. So let's take, for example, where you got an apartment from an agent. Okay? You know, I always use that apartment and agency thing because most of the times you guys are now doing that, and it seems like the most serious type of contract that you guys has actually been involved in. So let's assume the agent got you an apartment. He gave you the key of the apartment. But on the day that you want to enter the apartment, remember when he entered, he gave you a letter, because these are the things that most of the time we don't look out for. Before you give an agent the money for an apartment, it's always good that you let him show you his letter of authority from the landlord, where the landlord is saying, I authorize Mr. This and that to be my agent. Okay. So let me just go ahead with my example. And you went ahead, you made the payments after the man had shown you his letter of authority and all of that. But when you got to the apartment, the key that you slot in would not open the door. You called the agent said, oh, but the landlord is in the house. You went to meet the landlord, and the landlord started telling you, no, this house is not for you. I have rented it to somebody else. In that case, you can either sue the agent or the landlord, or you sue them jointly. All right? Because it is assumed in law that an agent is representing the principal. And in this case, the principal is the landlord. So what it means in law is that wherever you see an agent, it is as if you are seeing the landlord. So that is an example. Okay? That is an example of an exception to that rule. And so we have more of the exceptions, which I'm going to explain to you. Please, at this point, did you understand the concept and the exception? At this point, did you understand the concept of privity of contract and the exception? I need your responses in the chat. Okay, so let's go ahead. Now I'm getting your responses. Thank you. So we are going to go ahead and look at other exceptions. I have given you one exception. One exception is agency. So I'm going to type it in here. So that is an exception. One of the exceptions is agency. So number 2 exception is trust. The issue of trust. So in this case, and I think I gave you an example of trust yesterday, where 2 people entered into a contract and there's a third party who is expected to benefit from that contract. In such a case, the beneficiary of that contract can sue either of them for enforceability. So, outside of this part of the world, there are times that grandparents would drop some money in trust for their grandchildren. So they would enter into a contract with the parents of those children that I am giving $10,000 to your child, who is my grandchild, in preparedness for their university education. Now, if at some point the grandchild got to the stage of getting the university education and he was requesting his request for that, or he has actually applied, and the money is not paid to the tertiary institution, the law says that he can sue either of them. He can sue either the parents or he can sue the grandparents to enforce it. Okay? So I hope that is not strange to you. I hope it is not strange. Yes, the grandparents too. Because remember, they have entered into an agreement. They have assured him that, come, we are giving you this money. Somebody is laughing. Yes, that is it. It is your word. You have said, oh, I'm giving you this money. And you have signed a paper that I'm giving you. And tomorrow he discovers that, oh, that money is not there again. Okay? So you can also do more research on it. And that is why you are here. You can do more research on it. You know, in law, it is stated in law that trust is a creation of equity And so they are governed by equitable principle. Okay? So in equity will always try to protect those that contract would affect. Somebody has been happy, he has written some exams, he has been given admission, and he had been promised ever since he had understand his right hand from left hand that don't worry, we have put some money in safe for you. And when it got to that stage of putting the money is not there. Okay, so the law of trust says that he can sue either of them for enforcement of it. So I will expect you to read better on this concept, okay, on this exception. So the third exception has to do with assignment. Assignment. So assignment has to do with transfer of benefits. Okay. So let's say, for example, your parents, I will use this again. Your parents in their lifetime, they bought a property. Let me be real now. Your parents bought a property or I don't really even have to use your parents. Or let me just use them for emphasis sake. They brought a property and they transferred the property to you and they signed it. Property transferred to you. They cannot tomorrow come back on the transfer, especially for if those transfer has been registered. Especially if those transfer has been registered. So the rule there, the effect of transfer is that the third party becomes entitled to sue either of the party. Okay, so the third party can sue either of the party. Also has to let's look at exception that has to do with land. You know, let's say for example, a man, his parents are died. I am still hearing some people.
I don't know. I think
I hope you know I'm writing your names down. I hope you know I'm writing your names down.
Fẹ́ sọ bí Olúwa ṣe ìtàn.
So Clement says in the case of a house rental, for example, what happens when the landlord of the building sells off the building to developers while tenants are still in the building and their rent is still valid? Of course, you can go and sue the landlord now. You sue the landlord to get your money back from the landlord because he has collected money and you have an agreement. Okay. So going forward, when it has to do with land, okay, so let's assume your parent bought a property, or not your parent now, Mr. Gbadamosi parents bought a property in their lifetime, and they had willed that property to you, or they have willed that property to Mr. Gbadamosi. So, in the absence of the parent of Mr. Gbadamosi, if the person who sold the property to them maybe infringes or breaches the contract, Mr. Gbadamosi can sue the person who has breached the contract, even in the absence of his parents. Okay, that's covenant that has to do with land, exceptions to covenants that has to do with land. Also, we also have in cases of insurance. So let me try to write them here. So I have mentioned trust, assignments, covenants, Okay, so let me see.
Everybody, I just a ball like
Fuck.
So did you see what your colleagues are doing? Did you see how okay, so let's look at some. So why is Shobi? What's funny? David, what's funny? What's funny?
Only join, and you know, in my they are hearing eyes for 1 to 700. You got to go young
Okay, so let's go ahead. Another exception is statutory exception, and this has to do with insurance. So I hope you know that a third party, in fact, we have a third party insurance. That means a third party can actually enforce insurance that a company has with an insurance company. So if a company's cars hit a private car, the private car owner, if he knows or if he can detect the name of the insurance company, can request that the insurance company do the needful by maybe repairing the vehicle. Okay, so that's for that. That's for statutory exception. Please, at this point,
over for some days. They don't have license.
Are we on the same page at this point? Please,
I don't know.
Are you going along?
No.
Each person has a particular category with a particular objective. So you know what you have done. You are going to report on what you have done. If you read the file, it's not okay.
Yeah. So yeah. So a follow-up question to what you just asked, and I'll ask like that of the contract. Follow-up question is: you said you're going to keep track of all expo activities that are right. So I'm not going to speak perspective that say I'm also a member of the expo team, and we have some plans.
I try to mute everybody, and this thing is still coming up. I've done that.
Do you think
I have mute everybody? So why
although it's part of the task that person meant to like handle, do you think it is okay for an expo member to put something out when they are not?
So some people are in this class, and also
because if you have that kind of thing, tracking system that you wanted what transparency, but you also have to understand the fact that you won't be able to like open up everything.
Okay, so I asked a question. I said I have mentioned trust as an exception, agency, assignments, covenant and statutory exception, which has to do with insurance. At this point, are we on the same page? Are we together? Okay, please. So let's go to the last exception, and that has to do with bankers and commercial transactions and commercial credit. So, you know, another exception is there are some times that you want to buy, maybe you are into business, you want to buy some things from China, you know, and you have ordered for those items, but you were skeptical in giving them the money. So the way that people have been doing it, banks have been doing it, you can drop that money in the bank on behalf of that Chinese company. So immediately they send your money to you, the bank will forward the money back to them. So in case there is a breach, maybe at some point, maybe you want to withdraw from that account, the Chinese company can sue Chinese company can either sue you or sue the bank to enforce the contract. You know, the Chinese company can stop you from withdrawing from that account, and also they can ensure that the bank forward all the required sum to them. Remember that the contract is not between the Chinese company and the bank. It's purely between the buyer and the bank. So in this case, this is an exception where a third party, the Chinese company, can sue for enforcement of such a contract. Okay, so let's just go ahead and at this point, do you get me? And I want to ask a question. I want somebody to just write in simple terms, what is privity of contract? What is privity of contract? In a simple term, what is privity of contract? I'm waiting for the explanation of what privity of contract is. Okay, thank you. Doctor says privity of contract is the legal principle imposes obligation. Okay, so can you give me the exceptions? What are the exceptions? List the exceptions of privity of contract. What are the exceptions? Okay, yes, I'm seeing trust, agency. Somebody just went to copy what my goodness. And just, okay. All right. So at this point, I'd like you to clap for yourself because you have done so well as regards that topic. Please clap for yourself. Okay, so that's good. That's good. That's good. I'm clapping for you too. You have done so well. So our next topic is we are going to start a set of topic now. It is called vitiating elements. We call them vitiating elements. So this is what we are treating now, vitiating elements. Have you seen it? Who said depreciating? I've written it. Oh, it's vitiating elements. So just so those that are writing yes, why are you writing yes again? Yeah, vitiating Someone said deviating. No, vitiating, V. Okay, so yeah. So what it means in essence is that, you know, like we have said, we are giving you the basic concept of contract. We are giving you the elements of contract, the things that should be included in a contract. And we have told you categorically that immediately those things are present in a contract, it makes the contract valid. Okay, we have said that quite all right. But there are some things like one of the things that I explained. What did I explain yesterday? What was our topic yesterday? But I should have started from that, but let me just start from there now. What was our topic yesterday? Beautiful. So we treated capacity. And I mentioned the fact that if capacity is absent, if the person does not have capacity, that person cannot enter into a valid contract. Okay, so we said it can enter into, the contract can be made void or voidable. So thank God we've agreed on that. So what vitiating elements means, or vitiating element, what they mean is that the things that you can see in a contract that can make the contract void, or that would tarnish, or that would not make it a good contract. And those things are mistake, misrepresentation, duress and undue influence, and illegal contracts. So I'm going to repeat myself. Mistake, misrepresentation, duress, and undue influence. And the last one, illegal contracts. So thank you. Someone else had written it out. Mistake, misrepresentation, undue influence, and I'd also written it. So those are the things those are the elements that immediately you notice this in a contract, you would know that this contract is not a good contract. This contract can be void or voidable. So thank you. It's not totally void. There are some that can still make it voidable. That means you can still correct the abnormality. Okay? So those are the elements that when you see them, no, please don't write capacity. Don't put capacity in this vitiate. Thank you. Alonge says capacity and vitiating element. Good job. You have done well. Adekunle, you've done well. So I want us today to talk about mistake. So because I know all of you, you are in your final year and you are all now ready to go to the labor market, or would I say favor market, as you all will say it. So you are seen as experts in your field. This is your final semester. You are seen as already good enough to go out there. So I'll be doing more of questions so that I'll get to know you better, or to know that you are prepared. So I want to ask, what is mistake? Especially, remember when I was talking about capacity yesterday, I said when you are defining concepts in law, you have to take your time to define it according to the concept in law, not in the general parlance. What is mistake? Except if you want to give me mistake in the general parlance and mistake in law. Okay, Daniel says error. So Daniel is trying to be safe. A good explanation. Okay, he also said misalignment of contract ethics. Not totally, but then it is part of it. It is part of it. You are right. I think I would also want to say misalignment. Okay, that's also good. of contract ethics. Okay, good job. So somebody went to copy and paste here, misunderstanding or incorrect belief. That's Chika. You did well, at least you wrote something here. That's good. Mistake simply means error, misinterpretation of contract. Good job, Afolabi, that's good. So Clement says mistake refers to when one or both of the parties are allowed to repudiate a contract on the. Oh, good job. Somebody has just gone online to just copy and paste here. Error not made not with the intention to breach. You don't have to go online. Just give me your own. I'm not going to beat you. Nobody's going to accuse you. It's good that you are making attempts. Okay? So Ademilade says misunderstanding in the interpretation of terms of contract. That's good too. Good job. So Rafi says it can be intentional or not. Not really. So Ayedun says the mistake means that one or both parties entered into a contract based on an incorrect belief about. Good job. That's good. That's good. That's so good. So let me just use an example. Let me use example because most of the times examples actually drives home the points, okay? Let's say, for example, Mr. A wants to buy a car from Mr. B. And after they brought the car, he just saw that, wow, but I thought that this car is a 1990 model and Mr. B had sold a 1980 model to me. I will repeat myself. Let's assume Mr. A wants to buy a car from Mr. B and Mr. B delivers the car to Mr. A after Mr. A had made the payment. It was upon delivery that Mr. A discovers that the car is a 1980 model, which he has intended. He had he had thought that the car is a 1990 model. Now, in a normal balance, you will say that is a mistake. Mr. A will say, oh, but I made a mistake. Oh, I thought. In law, that is not mistake. In law, that is not mistake. Okay? So, in a general balance, that is just mistake. But in law, it is not mistake. Did you get my explanation? So that if this is given to you in exams, you will know this is not mistake in law. So, mistake in the legal sense it is very limited. Mistake in the legal sense, so Nana, I should explain. I've explained a lot of times. Don't worry, I will do my best. I just want you to calm down and listen to me. So, mistake in legally, mistake is very restricted. It is not as wide as you will see it in the normal balance. So let's say, for example, if B had 2 cars, my initial example is that let's assume Mr. A, I'm repeating for you, Inena. I think Inena says I should explain again. Somebody says I should give another example. Please just listen to this example because this is what will propel us in our further explanation, okay? So I'm going to repeat my explanation and example. I said, let's assume Inena, or no, it's not Inena, it's Unwane. Unwane wants to buy a car from Okonkwo. So I'm using you both for this example so it can stick better in you. Inwane wants to buy a vehicle from Okonkwo. He made payment for the vehicle and Okonkwo delivers the vehicle. Upon delivery, Nwane discovers that the car is a 1980 model, but in his mind, which he never expressed to Okonkwo, he thought that the car was a 1990 model, but Okonkwo delivers a 1980 model. In law, that is not a mistake. But in the general parlance, Nwane will say, I have made a mistake. But in law, that is not a mistake at all. Because even in the first place, you never expressed your intention to know, or you never make inquiries. Afolabi says scam. It's not a scam. Please, is it Nwane had made the mistake or has not expressed himself? But when it becomes a mistake in law, I'll give you the example. Let's assume Okonkwo has 2 cars. Okonkwo has 2 cars. One is a 1990 model, and the second is a 1980 model. Okonkwo or Nwane then expressed his interest to Okonkwo to get one of the vehicle. Okay? So immediately he made payment. In this case also, he did not give any intention. He did not tell him, oh, I want A or B. Okay? Then Okonkwo delivers the vehicle. While they were doing the transaction, Nwane thought Okonkwo want to sell 1990 vehicle to him. And Okonkwo also thought Nwane want to buy the 1980 vehicle. They both are thinking. In this case, they have both made a mistake in law. If Okonkwo eventually delivers the 1980 vehicle as against the 1990 vehicles that Nwane wanted, now they both are making the mistake because we have 2 vehicles available in this case. Now, I don't want you to think too far. Limit yourself to my explanation. It is when you start thinking too far that you take it, because a lot of the time you can think mistake is very hard. It's a hard topic to understand. It's as simple as I'm explaining to you. If at least a question will come out, it will come out in the way I'm giving to you like this. I'm not going to confuse you in the exam hall. In the exam hall or in test, I'm going to give you exactly what I'm giving to you. If I'm not giving you what I'm giving to you, it's a wrong question, and we will not give you a wrong question. So just limit yourself to what I have. Okay? So I have given you my example. I hope at this point you understood my example, because that is what would help us to understand better. Okay, so at this point, I'd like us to now look at the types of mistakes that we have. Now, remember we have told you to get the textbook, Akonki textbook. You will better understand the law of contract with it. And if anybody is going to set your question, they are going to set your question from Akonki textbook. Or it is even okay as a student in a tertiary institution for you to also read wide. Even after you had read Akonki, I think there are some other textbooks. Anyway, I know there are some other textbooks on law of contract. But if you can just read Akonki, you are good to go. Okay? You can buy it anywhere. You can just get, I think they also have it in the library. Okay, so I think Dr. Lobiso said she has. But then let me just read it out to you. It is called Commercial Law in Nigeria, edited by E.O. Akonki. Commercial Law in Nigeria, edited by E.O. in Akonki. So that's it. Commercial Law in Nigeria, edited by E.O. Akonki. All right, so let's go forward. So we are looking at the types of mistakes. So under the types of mistakes, we have common mistake, we have mutual mistake, and we have unilateral mistake. I'll repeat again. Common mistake, mutual mistake, unilateral mistake. So what are common mistakes? So common mistake arises when both parties share the same mistake. They are both mistaken as regards the same thing. Okay? Let's say, for example, two people, they entered into a contract. Mr. A wants to buy a house from Mr. B. Mr. B has gone ahead. The house is at Ibadan. Mr. B had gone to, yeah, thank you, Elutebe. So Mr. B had gone to Ibadan. He has checked the house. The house is in good condition and all of that. So he came back to Lagos State. He sat down with Mr. A, who was to sell, who is the seller. Mr. B is the buyer. They sat down together. They drafted an agreement, a contract agreement. They both signed the agreement and money had exchanged hands. Unknowingly for the two of them, that same money that they were signing the contract, that house got burnt. That house got burnt. In that case, there is nothing to contract on because the subject of the contract has been burnt down. So there is really nothing to bargain for. So in that case, they are both mistaken on the same thing, which is that the subject of the contract has been burnt down. There is nothing to contract on. So Mr. B cannot accuse Mr. B, Mr. A, for cheating him that, oh, but you know that the house is burned down and you came to collect money from me. Neither can Mr. A say, oh, but Mr. B, why are you just laying claims? Why are you just accusing me? So in this case, in law, like I'm saying, in law, it is regarded as a common mistake because both of them are mistakenly, they have mistake on the same thing. Do you understand me? So let us look at the second one, which is mutual mistake. Okay, so can you hear me? So who else can give us an example of a common mistake? So that I will know that I have actually given up my point. Do we have anyone willing to give the okay, so Timileyin said, of course, there's no contract. So please excuse me for just a minute or two, please. Okay, so I'm seeing an example here that a wholesaler selling cartons of, okay, noodles. Okay, someone said, what if the house is sold to be is situated in a place that is on in which uninhabitable? Okay. In which case the subject matter of the contract is still exempt but of no benefit. Are you going to buy a house that you have not checked? Will you be paying for something you have not checked? Of course, you would have checked the place, and if he likes it, it's okay. If he doesn't like it, that is detriment. How will you go and buy something and not have looked through it and all of that? That is not due diligence. You need to have, that has nothing to do with mistake. Okay? Okay, so thank you guys. It seems that we are doing well. But like I told you, please, I need the class rep. These class reps of this, okay. I think Jonathan, we agreed that Jonathan be the try to coordinate. Please, in your class rep chats, WhatsApp chat, I like you to please write the number of students in each department, because I'm seeing just 197 students. And I went to my YouTube page, there's nobody there. You see, there's nobody here. I'm the only one there. So that means you guys did not so by the time the test or exam comes and some people are not allowed into the exam hall, there's nobody to be blamed except them. Oh, common said it's slower. But then there's nobody here. At least this place can take 300 students. If it's slower, it means that, oh, it's something that comes after this one. It's not as if it's taking it, it's not happening, it's not concurrent thing. It comes after, but then if they are there, that means. So let's just go ahead so that we don't waste our time. So that's for common mistake. Let's look at mutual mistake. No, please don't go too deep. Joshua said, so basically a common mistake, taking an action based on thoughts, not expressing. No, that is not that's not the example I gave you. Please just sit down. Think of the example I gave you. It's not by thoughts. It's not by anything. You cannot enter in, and that's what I was trying to establish. So please, let's just go ahead. Mutual mistake. Because that means we are not going to live here. So mutual mistake occurs where the parties misunderstand each other. Simple as that. Their mistake is not common, but they made a mistake. Although it's because they did not understand each other. So before I go further, who can give me an example of this kind of a mistake? I have given that example here today, where the both parties misunderstood each other. If I can see anyone that can give me my same example, I really appreciate that person. I said mutual mistake occurs where the parties misunderstood each other. If somebody said the example of party. No. It's not about signing a house. I am giving the example. So, Oluwatobiloba, you are not okay. The example of Okonkwo here. So somebody is there. So this man, I'm trying to get you. Okay, where are you? So let's look at Clement. Clement says, for example, if they ask two cars, beautiful. So let's clap for Clement. Clement Benjamin. Yes, Ilesomi has said the same thing too. So that's just it. That is mutual mistake. they are both misunderstood on the contract. Okay, so that means you guys are actually following me. That's a good thing. How I wish I can just call you based on this. So let us look at the third one. What did we say the third one is? What did we say the third one is? Unilateral mistake. Good job. So in unilateral mistake, one party enters into a contract under the mistaken belief about some material facts, and the other party is aware of the mistake but still exploits the situation. Okay, I will say this again. Unilateral mistake occurs where one party enters into a contract under a mistaken belief about some facts, and the other party is aware of the mistake but still exploits the situation. So let me just give you, let's just go ahead. I will use that same car thing. Okay, Mr. A and Mr. B. Mr. A wants to buy a car from Mr. B. And when he saw the car, he was looking through the car and all of that. And he says, oh, this must be a 1990 model. This is actually a 1990 model. Mr. B kept quiet, did not say anything. Whereas the car is a 1980 model. So immediately the guy said all of that, though there was no response from the other party. He went ahead and made the payment. Under that case, that is called a unilateral mistake. That is a unilateral mistake. Did you understand me? Do you understand me? Okay. So what then is that? Now we have explained all the types of mistakes that we have. It's just as simple as that. Now, what you are talking about mistake. What is the effect of mistake? What is the effect of mistake? What is the effect of mistake? If we want to look at the effect of mistake, we will look at it under common law and under equity. And remember, okay, thank you. Oladapo says it voids a contract. Under common law, mistake voids a contract. But under equity, the law gives discretion to the court to decide on what will be favorable on the person who is at the extreme end. I mean, the person that the contract really, really affects. So I'll repeat this. Under common law, a contract is declared void when a mistaken contract is declared void under common law. A mistaken contract is declared void under common law. So Oladapo Daniel, I am saying this void happens only under common law. And like I explained to you, common law has to do with those laws that has come over the years. It has to do with statutes. It has to do with written laws. But under equity, that is fairness. The law says that, come, let us give the discretion to the courts. Let courts have the discretion to say, oh, if B thinks that, oh, is buying a car that is a 1990 model, whereas it's a 1980 model. A court may say, but why didn't you ask in person? Why were you just assuming? You should have asked him. And, you know, in that case, the court can say, oh, it's not totally void, it's voidable. It can be giving damages. Instead of saying return all of my money, you can say return part of the money and give him and ensure that you sell it to him in a, you sell the amount that will be sold if it were to be a 1980 model. Did you understand me to this point? So that I won't just be speaking into the air. Okay, so that is the effect of mistake. So I want you guys, everybody, please write the effect of mistake under the comments section. What is the effect of mistake and how, explain it properly. You don't have to use long language, just tell me how the law sees it. Mistake. What is the effect of mistake? I need a response from everybody. So somebody just said it's void under common law, yes, but under equity, what happens to it under equity? Okay, so you guys are saying it is void under common law. Okay, what of equity? I want to hear discretion. Under equity, the law has given the court discretion. Beautiful. Thank you, guys. That's good. I hope as we are doing this, I'm not going to see any mistake in your exams. I don't want you to write a test and you don't get all these things. All these things are very simple. Okay, so for those that are not contributing, you know I will get you. I hope you know I'll get you from the chat box. Okay, so let's go ahead. After we have treated the effect of common law. The effect of mistake at common, their effect in general. Now, this is how it is also treated further. Mistake at common law. Common law takes it takes the view that where a mistake is such that it prevents the formation of a contract, then the purported contract is void. So what I'm saying in essence is that if the mistake affects the formation of a contract, you know, if the mistake is such that it affects even the, you know, the foundation of the contract itself, that is void. Okay? If it affects the foundation of the contract, it is void. Okay, let us look at it in different way. Number one, there's a mistake as to the subject matter. When we are talking about the subject matter means the purpose, the reason why they enter into the contract. So when I gave you the example of the common mistake that I said the house got burnt, the subject matter of the contract is the house. I hope you understand. When I'm talking about subject matter, the subject matter of that contract, I mean, when I gave the example of common mistake, is the house. So let us look at the effect of mistake when it comes to the subject matter. So the circumstance which this happens is, let's talk about mistake as to the existence of the subject matter. So when unknown to parties, the subject matter of the contract does not exist at the time when they make the agreement, the contract is void. So I will ask this question. That common law, that common mistake that we cited, that we said when they were signing it, they didn't know that the house was burned down. Is that void or voidable? Is that contract void or voidable? So thank you, Chika. Chika said it's void. It's void because there's nothing else to do contract on again now. So the best thing is for the buyer, is for the seller to return the money back to the buyer because there's nothing. Okay? So thank God you're following me. There are also some mistakes that arises as regards the ownership. As regards the ownership. The principle applicable to cases of the ownership has to be extended. So the mistake lies in the identity of the owner of the subject matter. Let's say, for example, Mr. A paid for a piece of land. So Mr. A did not know, both parties, so unknown to both of them, the land already belongs to Mr. A. So I'll give you the example again. You know, I'm sure in your mind, you'll be like, where can that exist? That cannot exist. Let's assume. Let me look for somebody to use. Okay, let me use Ajayi and Oshola in your class now. Ajayi wanted to buy a property, a landed property from Oshola. Okay? Unknown to the both of them, Ajayi is the owner himself. He owns the property. You know, it can happen at times that your grandparents had willed something for you that you didn't even know that that thing belongs to you. Let's assume Ajayi never knew that that land belongs to him. Maybe his parents, his grandparents had actually willed it to him. But because he likes the place, he had contacted Oshola. The Oshola did not even know that the property is not his. Maybe he also got the property by mistake, or he mistaked it. You know, in that case, will it be void or voidable? Will it be void or voidable? Or do you want me to give you the instance again? Okay, somebody said voidable. It's not voidable. It's void. Remember, the property belongs to Ajayi. So are you now saying that Ajayi we say, oh, just let me take half of, he has made the payment. He's expected to take his money back because the property actually belongs to him. There is nothing to contract on. There is nothing. You cannot base something on nothing. That land doesn't belong to Oshola, it belongs to Ajayi. So it is void. So I think, Oluwatobi, you asked what's the difference between void and voidable. Did Dr. Ilobiso not teach you void and voidable contract? Please, I want you guys to be sincere here. Did she not teach you void and voidable contract? I want to know, please. So, like your friend had explained, what it means is that void means it is void. There is nothing. That thing is gone. It is, in fact, it is dead on arrival. But voidable means there is a remedy. It can be resuscitated. That's what it means, okay? So I think we should go ahead, right? So I think that example really actually had stated it all. Okay, so when it comes to the identity of the subject matter, I want us to move more to mistake as to the quality of the subject matter. As to the quality of the subject matter. So, for example, a common mistake which relates only to the quality of the subject matter is not operative mistake, and so it does not render the contract void. So, this is actually very, very dicey, because if you buy a car, I won't even go to that area. Should we use a car now? Okay, let me use a phone, except that I'm not well knowledgeable when it comes to the place of phones. I see that they are dropping something and I can't say. So when you are talking about the quality of the subject matter, you bought a phone and this is not functioning well as you expect it to function. Is it void or voidable? You bought a phone, immediately you open it, it wasn't functioning well again. Or you bought a fridge, it's not cooling as expected. Is it void or voidable? Wow, you guys are doing well. It is voidable, because have you not seen the situation whereby you buy such a phone, you return it back to them, they will tell you, oh, come back in 7 days, we are going to repair it. What it means is that it is redeemable. They can repair it and make it better. So mistake as to the quality of the subject matter renders the contract voidable. It renders the contract voidable. I hope as you are answering my question, I am seeing you type. I hope you understand it very well. Please ensure that you're understanding what I'm doing. Don't let us make this our time. So let us also look at mistake in equity. All I've been explaining so far is mistake in common law. Okay? So, and in common law, we've also actually been able to get that some of them can actually be voidable. Although we say they are void ab initio. So in mistake in equity, like we said, the law gives discretion to the courts. So the court can either say, oh, it is void or voidable. So in cases where the court sees that it is voidable, we have some remedies available. And the remedies available are rescission, rectification, and refusal of specific performance. Okay, so if in the case of equity follows common law and the contracts may be rendered void. So when a person enters into a contract under a mistake, which is like under common law, the mistaken party may obtain equitable relief from his contractual obligation. Okay, so even at common law, if you are saying, oh, this is what the statute say, the statute say, oh, That is common law, like I said. But the law has given the courts a discretionary power. The law has given you, okay, I will repeat again. So Eluti Bey says I should repeat it. When you are talking about equity, all these things that I've been explaining that they are void, especially when they are in court. You know, in common law, we are saying some of them are void. And we have even said, oh, some of them are redeemable. A court will now look at the circumstance of the case. The court can then now give this thing, can say, oh, do we set aside this contract? Can the party ratify it? Or if a party has made a mistake, which makes it unfair to enforce the contract, the court may refuse to order specific performance. Please, I don't want you to be confused, please. So what I'm saying under equity is that equity can try to equity because of the discretionary power of the court. Yes. I listed ratification. I didn't say restitution. Ratification, rescission. Rescission means set aside. So I'm just going to write them here. Rescission. So that's rescission. What it means that the court, in its equitable power, okay, the court can give these orders. The court can say, oh, come, let's set this contract aside. That is, it will be assumed as if they never entered into a contract. Okay, in all of the examples I've given to you, in what case, in which of the example do you think the court can order rescission? I will explain what rescission is again. I said the court in rescission can set the contract aside. That means the court will assume that the contract never happens at all. Thank you, Oloyede. Oloyede in the case of the burnt down house. Thank you. You are following me. Another order that the court can make in its equitable power is ratification. So that means the court can actually say, oh, maybe because the party has done some things afterwards, the party has ratified it. So let me make an example. In the case of the mutual mistake, where the other party bought, when Mr. A has 2 cars and Mr. B mistaking, there was a mistake as to him buying a 1980 car instead of him giving a 1990 car. If after they are giving him that car, after 6 months, he keeps using the car. He knows that the car is 1980, he just accepted. That, oh, I don't want to fight, I don't want issues. Let me just go on ahead and let me keep on using this car. Who is this Olalekan that I'm seeing your face on my face? Okay, let me just keep on going. So in that case, in the case where the courts, where the person who had bought a 1980 instead of buying a 1990, and the seller actually had both cars, but he kept on using that car. He kept on using that car, even with the belief he now knows that the car is 1980. He just thought, well, I don't want stress, Jerry. Let me just keep using it. And he wakes up tomorrow and he says, come, no, I want to go to court. And he goes to court. Under that court, the court would, in its discretionary power, state that he has ratified it by his action. And so the court will not see it as being void again. The court will say, because he has agreed by his action, the court can say he has ratified it. Do you agree with this ratification? Do you agree with it? Are you okay? Do you think it's a good thing to say, oh, for the court to say, oh, it has been ratified? Okay, you guys are saying it is okay, it is okay. Okay, that means okay, so I want us to lastly, I want us to talk about documents mistakenly signed. Let's assume you are the judge. They brought a case before you that Mr. A mistakenly signed a document. And afterwards, he now came back and said, come on, I did a mistake by signing this document. As a judge, how will you decide the case? Did you understand my question? Okay, so Ilesomi, are you answering my question or you are saying what we have said first? What I've already... So the question is this. I said, let's assume you are a judge and they brought a case before you that somebody says, oh, he had mistakenly signed a document. How will you judge it? Are you going to say, oh, it's a mistake, oh, let us just allow you to slide, or you would say, oh, you cannot bring this kind of thing before me? Okay, so somebody says it's not a mistake. So under the law, generally, the law thinks that it is wrong for you to come and tell them that you mistakenly signed a document. So as an engineer, if you are entering a contract, is it a contract of service? Is it a contract that's strictly to build something or to innovate something or whatever? You cannot sign a document except you have read it through, you have gone through it. It's always good to say, oh, let me take it home or let me take it to my lawyer to go and read it. Then I'll come back signing it. Somebody said the court will dismiss it. Of course, the court will dismiss it. So you cannot say, oh, I mistakenly signed a document under the law. It is wrong for you to come and say that. But like I would always say, in law, there are exceptions to all things in law. There are exceptions to all things. So the law developed a defense, which may be possible and be open to a person who has signed a document mistakenly. For example, where we call it in law non-ex factum. It is not my deed. It is not my deed. Let's say, for example, a person had a deed. A deed always happens. A deed is called a contract of land, especially in landed documents. We call landed document deed of agreement, deed. So if a person had a deed and they read it over to him, and the reading did not correctly state what was in the writing, he could raise the defense of non-ex factum. So I will repeat this in the language that you would understand. So let me just write non-ex factum. Ex factum. So that's this, non-ex factum. What it means is that it is not my deed. It is not my deed. Let me just put it down here. No, Oluwatobi, I've written it here, non-ex factum. It is not my deed. So that is what it means. Did you all get it? Did you all get what I wrote there? It is not my deed. So what this means is that, when we're explaining capacity, when we're saying explaining capacity as regards an illiterate person, and one of your classmates was saying, I think there was a question as regards, what if that person read a wrong content to him and not the content? So this is where this kind of defense can come up. A person who had signed a document in which it is not the content that was read to him. Maybe something else was read to him as an illiterate person. The law will protect the illiterate person under this principle of non-ex factum. It is not my deed. Please, do you agree with this principle? Did you agree? Do you agree with this principle? Okay, so you are saying yes. But I want you to also have it in mind that I was thinking somebody will ask a question. That what if he's also lying? Oh, thank you, Covenant. Covenant has said a little bit of what I want to say. That she's saying no, she doesn't agree. Oh. What if that person pretends to be an illiterate? Or what if the person has come to court to lie? So the court now has decided on something. The court is saying, oh, it is okay for you to come with this exception, but we are going to restrict it. We are going to be meticulous in ensuring that we do all due diligence to ensure that you are saying the truth. So it is not just open to every illiterate person to come and be claiming that no. Some of them can be coming and be saying that, especially when that contract doesn't favor them. So the court is now saying that, come, you cannot just come here and be throwing these things at us. We are going to really, really vet you. We are going to ensure that you give evidence as to when it was read to you. If there's anybody that can that can attest to the facts of what you are saying, the court, in essence, or generally as it is now, the court has restricted that exception and has said that, come, if you sign a document mistakenly, it is your problem. But if you are coming with a defense of, oh, I am an illiterate, oh, it was not properly read to me, oh, I could not see it properly, oh, I did not see it because I can't see it properly and it was not read to me properly, you have to come with very good evidence and very good defense, except the court will not allow your defense to slide. So at this point, do we have any question? Because I want to just say some final words before I go, as regards what we just stated. So somebody said, what if a person is an illiterate and does not know about the modality to follow when signing? Remember that when we're treating Emmanuel, remember that when we're treating capacity yesterday, I made mention that there should be a person, the court expects somebody to be the writer of that document. The writer should be able to explain all of this to that person. And remember, you have to be careful. It is better if you want to sign documents ever. It is always good to have another person look at it for you, especially a lawyer. Everyone needs the service of a lawyer. You don't really have to go to all the SANs and all of that. You can go to lawyers that you can afford, or you can go to a friend lawyer. We are in Nigeria that where people are nice. Lawyers are nice to their friends. So I now want to give you the restrictions that the court have given, that these are the only situations, or that these are the restrictions that the court has given. That number one, the court is saying that this plea is only available to illiterates. So persons that are not illiterate cannot come up with it. Or is also, the court has also said that, oh, some people cannot even understand. You know, some people do not understand legal jargons. When you read, we call it legal jargon, our legal language. Some people don't understand it. It's not as if you are illiterate. It's just that you don't understand it. You can read and write in English. That is why I am proposing that if you must sign a document, take it to a lawyer. So the restriction is that it is only an illiterate or a person that can actually give evidence that I don't understand some of the wordings here. Another restriction is the nature of the mistake. So at a certain stage, it has been developed that the plea applied only to certain kinds of mistake. So there's a distinction between contents of a document and the character. So the plea could be available where the mistake was as to the character, not the content of the documents. As to the character, not the content. So let me give an the court held in the case that the plea was available only where the difference between the document actually signed and the document as it was believed to be was radical, essential. I mean the wordings of the document. Like I said, if you are when you see legal jargons and all of that, the court will not look at the court will not look at the character. The court will only look at the character and not the content. You cannot say, oh, this I'm coming because this person, this contract, they said is this house at this place, and I don't understand what they were saying. But you can only come when you are talking about legal jargons. You read it, you should have known that the house they are talking about is at number 19. You cannot say, oh, I read it and I thought it's number 20. No. You can only come when they are talking about wherein, thereafter, radical, when you are looking at big words. And like I'm repeating again, please do not sign a document if you haven't given it to somebody else to read. A lot of the time, some of us are always in a hurry because of maybe the gains that we get to gain after it. You just enter into some contract. Also, finally, you are going now. The plea is also only applicable to a party. I mean, the defense of, oh, I made a mistake to have signed it. It is only applicable to somebody that is not careless. So if you did not read a document, you just quickly went to sign it, you are careless to have signed it. But if you are very careful, you have given it to people, but still some mistake, you can prove or give evidence as regards these people that you have given the document to read. Okay? And so the court will have actually see that, oh, you have gone a long, you have done a lot of things to have seen that, oh, this thing, that you have done your due diligence. Okay? That you have done your due diligence, but when you haven't done due diligence, the court will not listen to your plea at all. So those are the restrictions that are placed on documents that are mistakenly signed. Any question, please? So Amosu says that, what if someone denies the signature on the contract? Is it void? Well, so you can only deny a signature if there's no witness. Of course, you have a witness now. By the time you sign a document, Was the other party there? Now, most of the times, oh, my laptop will be going down in like 2 minutes. Okay, but I will see what I can do. So somebody says, okay, let me quickly finish that explanation. Oh, how I wish I can remember what she asked again. Okay, about somebody sign. You know, like I said, when you go to court, I wish one of these days you guys go to court and see what happens there. You see, when you are saying the truth, it will be consistent. They will know the truth by you giving evidence. And also, in most of these documents that we sign, there is always witnesses. You are expected to sign a document in the presence of a witness. So if you have a witness there and you are still coming to say that, oh, I did not sign this document, then the court will probe into that very well and even ask the witness, were you not signed when this thing was signed? Were you not there when it was signed? So I think, oh, sorry, I think I saw. Okay, Favor asks, is contract law same as common law? So contract law developed from common law. Okay? Because if you can remember, when you started this, we mentioned Statute of Limitation, Illiterate Protection Act. Those are the laws that came out of common law. Contracts is like a big topic. But when you are talking about common law and equity, it has to do with just procedure. Common law and equity does more with procedure. But when you are talking about contract does more with substantive laws. So I want you to go back home and do a good research on substantive law and procedural law. Okay? So common law is just a procedure that they use in vetting all of this. You know, we have contract law, we have law of torts, we have family law. All of these, they have their places. They have a way that common law and equity applies. It is like you applying common law in contract. These things they are substantive law. So common law and equity, their application, they are just a form of application. I hope you can understand me. Okay? I wish you can understand me. But if you don't, let me just drop my email here. F Adewumi at tuning up.